Good morning. Happy Wednesday. Time flies when you're having fun. I woke up to this morning. Teresa had tagged me. She said that Earl wanted me to watch a video. And why not? Why the fuck not? Lido law video. Okay, he's an attorney. Great. He says that the lie detectors are inadmissible in court because it's the jury's job to determine who's lying. Okay? I believe I'd covered that. If you watch my previous Ramblin while Amblin, I stated that it is the role of the jury, not the role of a polygrapher, to determine fact. And one of the facts is who's lying and who's not. I'll bet it's a little breezy. If it is, I apologize. The next thing he covered is that it is an excellent tool that the police like to use in interrogations. And it certainly is. I 100% agree with him on that. And that's another reason why it's not useful for the police to have Earl go to the polygrapher of his choice at his time, at his convenience, when he's comfortable, to have him ask the questions that Earl has asked his polygrapher to ask. It's a polygraph measures your reactions to things. Some reactions that are theoretically hard to control, like blood pressure, heart rate, perspiration, respiration, things like that. It's supposed to capture all the evidences of stress. And if you remove all the stress from the situation, then and you're not being asked uncomfortable questions. I mean, interrogations work because you're in just like depositions, you're in a strange, unfamiliar setting. You have to be there. You don't have a choice in the matter. You don't get to control what questions are asked. You feel like you have to answer. You know, and it seems like the more agitated and upset you get, the more they'll ask you about that particular thing. It's very unnerving, and that makes people react and crack and tell the truth or tell more lies. People have different reactions. Anyway, I pointed that out in one of the first few videos I did after Earl's interview with the Deer Park police was released. Him going on to his own, getting his own polygraph done, is not at all what the police are interested in, because they want to ask the questions. They want to see him squirm. They want to follow up on things that they think he's reacting to, etc., etc. And the police can lie, absolutely, 100%. Now, where Mr. Lido, Esquire, and I disagree is he says that everybody who says it's easy to pass isn't a trained polygrapher, don't know what the hell they're talking about. And if he said that I, John, am not a trained polygrapher and don't know what I'm talking about, absolutely. That's why I didn't rely on my opinion. I relied on a trained polygrapher who made a video that was widely circulated on Discord when the polygraph questions were first coming out with the release of the Deer Park interview. And it was the opinion of that polygrapher. And you could probably Google it up. He goes around teaching people how to beat lie detector tests. I mean, whether or not it is easy to do, one thing that we do know is that Earl has beaten a lie detector in the past. So whether or not I can do it, whether or not you can do it, whether or not Mr. Lido, who also doesn't profess to be an expert on lie detectors or a trained polygrapher as far as I'm aware, while we may not be able to pass it, we know Earl can, because once again, when Earl was arrested, after having passed a polygraph about about stealing cars from that Ford lot. His brother pulled up in a stolen car from that Ford lot. Earl was the security guard there. Earl's the one who got him the keys. Earl was charged, I think, with it. I don't remember. It was convoluted. Earl had a lot of felonies, one of which was that car theft. By taking the keys, or by having access to the keys, it was a kind of car theft. Whatever, not relevant. Anyway, he lied, he passed. That's the point. He passed before. There's nothing to suggest that he couldn't pass again. It is still a ridiculous thing for Earl to have done. It was a waste of time. It was a waste of effort. It can't be submitted to the jury, either the grand jury or the jury in the criminal case. Earl still wasted his time. One thing that Alito's law didn't refute, didn't even attempt to, was that it still is inadmissible in court, and it is still not something you can get to the grand jury. So, thanks for wasting my time this morning, Earl. If indeed you did want me to watch that video, it was truly a waste. In other news, the Ginger Fuhrer, Jimmy Koresh Springer, real middle name Allen, lost his bid to quash the access to the Google account, to his Google account by the Bexar County DA in their ongoing investigation, or the police in their ongoing investigation. One thing that Jimmy Koresh, the Amish overlord, one of the things that he should understand is that he is not clearly innocent. If he was clearly innocent, then there would never have been a probable cause determination in the first place. There never would have been a warrant issued. I don't know if there's been a grand jury indictment on him yet, but these things are indicia of him not being clearly innocent. And one of the things that the police do, if they suspect someone of committing a crime, if they don't believe that person is clearly innocent and they have probable cause, is that they continue the investigation through warrants to either get exculpatory information or incriminating information. And that's what they're doing. So the Leon Valley case is marching along, or at least as far as it relates to James Freeman. And again, I'm not terribly convinced that what he did was criminal. I'm not convinced at all that what he did was criminal, but I don't have access to all the evidence. So it's kind of a wait and see sort of thing for me. Plus, I'm just a first-year family law attorney. Yeah. Anyway, I don't really believe that the DA agreed with Freeman's attorney that James is clearly innocent. I think James is fabricating that. I also want to point out that James's idea of what a good lawyer is and what a good lawyer does is a little bit warped. Good lawyers don't just do whatever the client wants them to, and it is not a matter of putting the client's opinions and words into magic legal words, into the right procedures to get them heard. When you have a winning case, when the law is on your side, you argue the law. If the facts are on your side, you argue the facts. If neither the facts nor the law are on your side, you argue emotion, opinion. That's when you make the arguments that Springer wants to start off with. And there's a reason why you do that. It's because the law wins, hands down, all the time. If the law says you can't do something, then you can't do it. Doesn't matter what the facts are. Doesn't matter what your opinion is. If the law says you could do it, well, then you have to look at the facts. Do the facts match what the law needs, wants, requires? Do these facts apply to this particular law? Does this particular law apply to these particular facts? You argue the facts. Facts are a little bit squishier. Facts are a little bit harder to pin down. But if you can't beat them on the fact or on the law, you go for the facts. Facts will beat art. Facts will beat opinion. The criminal court is not a court of equity. Its goal isn't to listen to your feels and wants. And so if you are a sovereign citizen, you are going to have a hard time finding a lawyer that is going to argue your way first, because number one, your idea about the law is wrong. Your idea of what the law says is wrong. That's probably why you're being charged with a crime in the first place. Your understanding of the law. That's one of the things that just is hilarious to me. People who don't understand my arguments, who don't understand what I'm saying and tell me I'm wrong, and then they point me at another lawyer or another person's opinion that mine is not in conflict with, that my legal opinion is not in conflict with, but they didn't understand what that lawyer said either. It's ridiculous. It's like NJ Diver posting URLs everywhere. URLs of articles he doesn't understand. Using them as either rebuttals or support for arguments he doesn't understand. James Freeman doesn't understand the law. He doesn't understand the law. It's retarded. Anybody who is in the legal profession can look at the positions that Freeman has on legal issues and just understand inherently that he's just fucking bass-backwards. The law is not what James Freeman thinks it is. That's why he's always in fucking trouble with the law. And so anytime an attorney is arguing the points that James Freeman wants him to argue, you know that attorney fucking ran out of solid legal footing a long time ago. And he's just fighting to fight at this point. He's running up fees, and he's making the client feel good that he's fighting for him. And I understand that, and that's, I've done that myself. You run out of law, you run out of facts, and your client wants you to fight on it. Fuck it, I'll go in there swinging. Worst thing that happens to me is the judge says, "I'm sorry, counsel, you're wrong on this." Okay, but hey, you know what? I could go out and I could clap my client on the shoulder at the end of it and say, "You know what, man? That judge is a big dummy. We had a great argument, man. I'm sorry." And that's what James Freeman, that's what his lawyer did for him. And I'm glad that James Freeman appreciated it. But I just want to make sure everybody knows that the reason why his lawyer did that, my best educated guess, having been in the field, if he's arguing Freeman's points, if he's arguing Freeman's emotions, he ran out of law. He ran out of facts. That's what happened. Anyway, thanks for watching. I hope everybody has a wonderful hump day. Can't wait to see more nonsense out of this community. Can't wait for someone to tell me that my legal opinion's wrong. But what do I know? I'm just a first-year family law attorney. Have a great day.